Withdrawal, Chelluri and Air India Ltd.
Yes, Mr. Gilligan.
My Lords, thank you very much. My Lords, my name is Mr. Harry Gillow, and I appear today for the claimant and the appellant in this case, which is to do with the interpretation of what was EU and is now UK Regulation number 261 of 2004, which I'll refer to as the regulation for the purposes of my submissions. My learned friend, Mr. Jacob Turner, appears for the defendant and the respondent in this case. My Lords, there are a few initial points I wanted to make before I start on my submissions. First point I just wanted to briefly say is to apologise for the length of the authorities bundle. The cases involving this regulation do tend to breed a large amount of case law, but I'll try and keep...
The French, German, Italian and Spanish versions. Are we going to refer to all those?
Well, I don't personally intend to, my Lord, but they are there because there is some issue as to the different language versions of the regulation.
As I think Mr. Justice Harman once said in a case I did many years ago, all English judges speak all European languages. I regret to say that's not the case in this court.
Well, my Lord, I sympathise with that because I have also struggled with some of the language issues in this case. And in fact, there's another initial point I'll come on to momentarily that deals with precisely that. But I'm going to try and keep the references to a minimum. The second point, my Lord, is that there is, between the parties, an issue as to the status of one of the cases in the appeal bundle, in the authorities bundle, which is the decision of the Frankfurt Appeal Court at tab 15, starting page C378.
Well, we'll look at it for what it's worth.
Of course. My Lord, I just want to note briefly on that I don't intend to make much of that, and I don't intend to focus any submissions on that at length. But the respondent takes issue with our inclusion of that on the basis that the respondent considered it to be foreign law. We are not applying it as foreign law.
I'm not sure that's his best point. Anyway,
thank you, my Lord.
You can say what you want about it, and we will evaluate it on its merits, Mr. Gillow.
Thank you, my Lord. And I place very little emphasis on that.
And Mr. Turner can say what he wants about it as well.
Thank you, my Lord.
I hope there'll be no issues as to the quality of the translation.
I don't believe there are, my Lord. But I'm happy to be corrected on that. My third point then, my Lord, is that the second ground of appeal I have in this case to do with the inviting this court to overrule Wegener if it doesn't agree with my first ground of appeal is very much a secondary point. I don't propose to spend much time at all dealing with that, and it's only in the instance that your lordships don't agree with me on my first point that becomes of any relevance at all. So I propose to deal with that very briefly at the end of my submissions. And then there's a further point, my lords, that it's been brought to my attention early this morning that the question at issue in this case has been referred to the European Court of Justice in another case, and a post-Brexit case from a German court, and that there has been an opinion...
So not a case in this jurisdiction?
Not a case in this jurisdiction, my lords, no. The relevance it would be that per section 6.2 of the European Withdrawal Act 2018, the court is able to take into account decisions of an EU court or an EU body on or after exit day. They're not authorities, they're not binding authorities, and they don't have the same force that a pre-exit day decision of the European Court of Justice would, but they do have potentially persuasive force, and they can be taken into account by this court. I don't propose to say very much about it because I haven't had an opportunity.
As it can the other way round.
As it, of course, my lord, yes.
They would doubtless be greatly assisted by this court.
Absolutely, my lord, yes. And all I propose to say about it is to draw it to your attention, my lord. I've got copies of the...
So it's a decision that has been made?
There has been no decision yet, my lord. There has been a reference and there's been an opinion of the Advocate General.
Right, okay.
The complicating factor with the opinion is that there is no English version of the opinion. There's only French and German versions.
Well, perhaps we'll try the French one rather than the German one, for me anyway.
My lord, that's why I brought the French. Certainly from my perspective, the German might be a step too far.
I mean, is it for you or against you?
It's for us, my lord. So, obviously, we would seek to persuade the court that the same approach should be adopted.
What's the case called?
The case is called Air Help and Austrian Airlines Limited. And my lord, I have copies of the preliminary reference and the French and the German versions, which I could hand up to the bench if that would assist you.
Do you have electronic copies?
I'm afraid I don't, but I could send you one, my lord.
Can you make sure you do?
Of course.
And try not to use paper.
So what's the status of the actual decision
So the decision...
before it goes to Europe, before it goes to the ECJ?
My lord, I'm not entirely sure. You mean the decision of the German court?
Yes.
I don't know, my lord. I'm afraid I've only had a half an hour to consider this, so I've looked primarily at the issue before the ECJ.
But you've got the Advocate General's opinion.
I've got the
which
Advocate General's opinion, yes, my lord.
Certainly has some status. I mean, does it say Wagoner is wrong?
It doesn't say Wegener is wrong, my lord. It says that Wegener should be interpreted in the way that we submit it as, or
Read
that's
down.
what we would say it says.
Should be read down.
Should be read down. So, my lord, I'd submit actually that, and I'll take you to this in due course, it's not necessary to read Wegener down. It's perfectly compatible with our interpretation of the regulation. But if I could take your lordships to the French version, paragraph 84, which is on page 11 here, and then the sub-paragraph 1.
Hang on, I don't have any French. I have German and English.
Ah, then, my lord, I have failed to provide you with...
I've got 2 copies of a request for a preliminary ruling in Landesgericht Korneburg, Austria. Is that one?
Apologies, my lord. I think I've failed to provide you with the right document.
I've got 2 copies of the French, so I can give one to my lord. I've got 2 copies of the Advocate General
There's another German.
in French and 1 copy of the Advocate General in German.
Heinrich Sogmansgaard. Is he the Advocate General in this case? Yes.
Right, just so that you know, I've got 2 requests, 2 translations of a request for a preliminary ruling in Landesgericht Korneburg,
But no.
which I'd happily look at in German if you want me to. And I've got 1 copy in German of Air Help and Austrian Airlines.
Well,
You speak German? Yeah.
I was once passed off as an expert in the German language, quite untruthfully, in the Winchester Crown Court, but don't worry about that.
thank you, my lord. I do apologise. This is entirely my own slightly haphazard organisation this morning when trying to provide copies.
No, I've got that.
My Lord will look at the German, and my Lord Justice Coulson and I will look at the French and see where we get to.
Thank you, my lord. And I should state at the outset that I haven't had the opportunity to read the entire of this, and neither my French nor my German are particularly brilliant, particularly my German. But turning to page 11 of the French and or German version, just below paragraph 84, you have there the operative part of the Advocate General's opinion, as subparagraph 1. And I have that translated as Article 3.1 of Regulation EC number 261/2004 of the European Parliament and of the Council of 11th February 2004, establishing common rules on compensation and assistance to passengers in the event of refusal, I should say, of boarding and cancellation or long delay of a flight, and repealing Regulation EEC number 29591, must be interpreted as meaning that this regulation is applicable to an air link operated by a community carrier which is consisting of 2 flights and which has been the subject of a single reservation, when the initial place of departure and the final place of destination are located in a third country, but the place of arrival of the first flight and the place of departure of the second flight are located in the territory of a member state, so that each flight taken separately falls under this provision.
So it's a community carrier.
It's a community carrier, my
So
lord.
it's not this case at all.
It's not this case in the sense that that might
It's
make
not
a
this
difference.
case at all. It's not the territorial gateway.
Well, my lord,
We are concerned with the territorial gateway.
I completely accept that, my lord, and I will come to my submissions
It's
on
not,
that.
so it makes perfect sense because it's an EU carrier. That's entirely in accordance with Wegener.
But my lord, I'd submit that if you look at Article 3.1a of the regulation, that provides a separate gateway when a flight takes off from an airline.
Well, we'll come back to that, but I'm just looking at this case, because you presented this on the basis that this was our case.
I understand, my lord.
And I've pointed out to you a fundamental difference.
Yes, my lord. I accept that. And
I'm very troubled about that.
I do apologise,
Speaking
my lord.
entirely for myself,
Yes.
you presented this as being on all fours with our case, and it's not.
I apologise, my lord. I meant no disrespect at all by that. I was going to actually address that specific point. But I do completely accept the force of what you say. I'd submit that in this case it doesn't make any difference because it's concerned with this point about whether or not you can break up flights, or break up passenger transports, as I would call them, into individual flights. But my lord, I completely accept the force of what you say, and I do apologise for that.
Where's the bit where he says that you should read down Wagoner?
My lord, I don't know that. As I say, I haven't had much chance to consider this, and I don't know if the case of Wegener is directly dealt with in this opinion.
Well, it's at paragraph 44. I think.
Which appears to be a summary of the facts of Wegener.
Yes, my lord. My lord, as I say, I really only present this to you for your information, and I'm not proposing to place any particular weight on it. My suggestion was going to be that if it would assist the court, there'd be written submissions on this point when all parties have had a chance to consider it properly. Because certainly I haven't had a chance to read it in any depth.
Well, I think you're going to have to do a bit better than that. I think you're going to have to get any submissions you want to make sorted out over the lunch and adjournment.
Of course, my lord, and I will certainly do that.
All right.
Thank you very much.
Let's carry on. Start at the beginning, perhaps.
Thank you, my lord. So, the final one of my initial points is just to note, and I only note in passing, the point about which law should be used in this case. So, both parties have taken the approach set out by this court in Lipton, which is at paragraph 82, and that's at tab 17, page C421 of the authorities bundle, that the relevant instrument is the regulation as amended. So it's the UK regulation, even though the facts of this case arose and the claim was brought before the UK's exit from the EU, before the UK's withdrawal from the EU on exit day.
I still don't really understand that point.
No, my lord, I was going to note that. So I think that that was a case which I understand from my instructing solicitor, who is also the instructing solicitor in Lipton, that the parties provided written submissions on the position of the regulation in UK law post-Brexit, and that the court at paragraph 82 appears to have, and I say appears to have, applied this as if the regulation that you apply for the purposes of a claim arising before Brexit is the amended UK regulation. But that isn't, there's no explanation of why you pick that particular point. And I do accept that it might be possible to read paragraph 82 as differently. It might be possible to read paragraph 82 as simply saying that the relevant domestic law going forwards is the UK regulation.
Well, I mean, if we're going to say anything about this, we better look at paragraph 82.
Absolutely, my lord. So if I could take you to tab 17, page C421 in the authorities bundle. And what you see there, my lord, at paragraph 82, which is just above B at the top of the page.
It's not hyperlinked, is it?
No, my lord, I'm afraid it's not, I don't think.
And which page is it in the authority bundle?
It should be page 421 in the authorities bundle. I believe that the page numbers match up to the pages in the PDF.
They don't even match up to the index.
Ah.
Okay. 421.
An electronic bundle that's not tabbed is worse than paper. My lord uses an electronic bundle and is always much more efficient. But if it's not tabbed, it's less efficient than us having the paper bundle.
I understand that, my lord. I do apologise.
Right, paragraph 82, applying section 29.
So applying section 29, there are 3 steps to take. The first is to identify the relevant domestic law. This is Regulation 26104 as amended. And my Lord, so far as I've been able to tell, that's the only point at which it's identified that the relevant domestic law for the purposes of the claim is Regulation 26104 as amended. So
it wasn't a matter of argument or decision.
No, my Lord. And if you look at paragraph 72, which is at page 416, you have there the point that seems to have led to this conclusion, where it says Regulation 8 of the Air Passenger Regulations 2019 amended Regulation 26104. The
Sorry, which paragraph again?
Paragraph 72, my Lord.
72. Regulation 8, yeah. Yeah.
The cumulative effect is that the present governing law is Regulation 26104 as amended. Now, my Lord, I'd accept that that's perfectly correct insofar as the law for any claims brought from this date onwards would be the amended regulation. But there appears to have been no argument as to why the amended regulation should be the law that you apply to claims historically. In this case, it makes no difference, my Lord, but you can see how it could have made a difference if, for example, the claimant in that case, or in this case, had taken off from a European airline located outside the UK. Because if a claim had been brought on that basis, then presumably, if the claim had been brought in a British court, their claim would fall away.
I mean, speaking only for myself, I can't see how it can possibly be right.
Well, my Lord...
The law was what it was when the claim was brought, and that's the beginning and end of the matter.
And I would completely agree with that, my Lord. I think there is an issue that this is obviously Court of Appeal authority, and therefore is binding precedent.
You're telling me it's not really authority because it was either agreed or not argued.
Yes, my Lord. So there is an argument for saying precisely that. And while I would note that it doesn't make any substantive difference for the purposes of this appeal, it is an important issue of principle, and it is one that would have potential impacts in other cases, particularly where there has been substantive amendment of the UK version of the regulation following Brexit. So if in the process of onboarding, the government has changed the details, the substantive details of a piece of law, as opposed to simply making it applicable to the UK, then that might have an effect on a party's claim. My Lord, I don't propose to say much further on that, because I don't really think there's much more I can say to assist the court.
It doesn't make any difference to your appeal.
It doesn't make any difference to my appeal, no, my Lord. But I wanted to note it regardless. Thank you. My Lord, I'd like to move on to my submissions in this case. And as I would put it, the issue for consideration is really a very simple one. It's whether a passenger on a series of flights, beginning and ending outside the UK, can, under the regulation, claim compensation for a delay on arrival caused by a delay on one of the connecting flights taking off from the UK. The appellant's case is that she is able to do that, and the respondent's case is that the connecting flights must be taken as a single flight, a single whole unit of flight, and that the appellant isn't therefore entitled to compensation because they don't come within the territorial scope of the regulation under Article 3. Now, my Lord, my submission would be to note at the outset that it's the appellant who is arguing for a natural reading of Article 3. And I'll take you shortly to the wording of Article 3 of the regulation to demonstrate this. My points that I'll come to later about protection for passengers and the principles of equal treatment under EU law do support the conclusion that I propose to your lordships, but it's my submission that the approach advocated for by the appellant would be the natural approach to take, regardless of any principles of EU law. And in that regard, I'd note that the respondent relies on a series of judgments from the European Court of Justice, starting with Wegener and moving through Chesky, I don't quite know how to pronounce that, my lords, and OI, the Air Nostrum, demonstrate that the regulation doesn't apply in this instance. So the respondent is saying, in essence, as I understand the respondent's case, that a flight has been defined by the Court of Justice.
Not a flight.
Not a flight.
Flight is not a word that appears in the original regulations or the amended regulations.
My lord, it appears in...
Neither does passenger transport. The word is depart.
I understand that, my lord.
It's the only word we have to worry about.
Absolutely, my lord. And I will come to the relevance of the word flight, which is that it appears in the German version of the regulation, which is why the Court of Justice has ever been concerned with this. But I'll rephrase the point, my lord. The point, perhaps better put then, is that the respondent says that when considering whether a passenger is departing from a European airport or a UK airport, if we apply the amended regulation, you only take the initial point of departure in a series of connecting flights, and you treat the entire of that series of connecting flights as a single unit, whatever, in practice, you want to call that.
Can we look at Article 3 of the regulation, the EU regulation?
Absolutely, my lord.
That was applicable at the time.
My lord, that is at tab 20, page C503, so page 503 of the bundle. And I believe, my lords, that there is a separate bundle that deals with the separate small file for those with paper bundles that deals with the legislative provisions. And then, my lord, the Article 3 itself starts at page 505. And my lords, what you can see here is that Article 3 is separated into two sections. So first, under Article 3(1)(a), you've got it applies, the regulation shall apply to passengers departing from an airport located in the territory of a member state to which the treaty applies. And second, at Regulation 3(1)(b), that the regulation shall apply to passengers departing from an airport located in a third country to an airport situated in the territory of a member state if the operating air carrier of the flight concerned is a community carrier. And I completely take my lord's point that that is where the relevance of community carrier in the recent Court of Justice case of Air Help comes into play. But my lord, I just wanted to focus initially on what would be, if the appellant's case is correct, the relevant passage in this case, which is Article 3(1)(a), and a statement that the regulation shall apply to passengers departing from an airport located in the territory of a member state, or as it is now, the UK. Now, my lord, in my submission, read plainly, that covers the position of the appellant, who departed, in the ordinary sense of the term, on a flight. I accept that the flight doesn't appear in the regulation, but they departed from an airport located in a member state. They departed from London Heathrow. There's nothing in Article 3 to indicate that the connecting flights are at all relevant to that question. And my lords, I'd submit to you that what you have with Article 3 is, as my lord said, a territorial gateway. It provides for when the regulation can, in principle, apply. What it doesn't do is state that wherever the regulation applies, there will be compensation. That's a separate question that you come to later through examining Articles 5, 6, and 7 in conjunction with the Court of Justice's case law that has extended the regulation's compensation for cancellation to cases of delay. But my lord, the first point in my submission would be to look at Article 3 and ask, could the flight that the appellant took from London Heathrow fall within the scope of Article 3? To which my answer would be that it could, and therefore that it should. But I will come on to my support for that later. So my lord, that is the essence of Article 3. And I think the easiest and the most productive way to move forward from Article 3 itself is to look at the case of Wegener, and what exactly that says. And it's my submission, as I hope to demonstrate to you, that on the natural reading of Wegener, that doesn't change this position, that a flight departing from an EU airport, even if it is only one of a series of connecting flights, brings the passenger within the scope of the regulation. And my lord, you can find Wegener at tab 11 of the bundle. Page.
You need to give us the page number
Of course,
because
my
we
lord.
don't have tabs.
Page 345.
You do, I see.
Yes, my lord. Page 345 of the bundle. And if, my lord, I could take you first to page 347 of the bundle.
And it is the same Advocate General as has just opined in the latest case.
Well, indeed, my lord. Although, of course, in that case, the Advocate General didn't provide an opinion in Wegener.
Right, well, even so. Yes, where are we going?
At paragraph 8 there, you have the question that was asked by the referring court, which is where this reference to flight creeps in to start with. Because the German court asked, is there a flight within the meaning of Article 3.1a of the regulation, where an air carrier's air transport operation, and that again is the relevance of air transport operation, includes scheduled interruptions outside the territory of the European Union with a change of aircraft. And then at paragraph 11, slightly further down that page, the Court of Justice reframed the question. So it said it should be considered that by its question, the referring court is asking in essence whether Article 3.1a must be interpreted as meaning that the regulation applies to passenger transport affected under a single booking and comprising between its point of departure and its arrival at an airport situated in the territory of a third state, a scheduled stopover outside the European Union with a change of aircraft. And then you have this point that I think has led to some confusion in the case, and I will come to in more detail later. But if you look at paragraph 12, just below that, the Court of Justice says, in the present case, it is clear from the decision to refer, first of all, that the transport, referred to in paragraph 5 above, comprises two flights connecting Berlin to Casablanca and Casablanca to Agadir, respectively. Now, if you look at this in the context of the German version of the regulation, which does use the word flight, I'd submit to you that what's being said is that there is a single unit of transport here, and that is the unit of transport that spans from Berlin to Agadir. But that unit of transport is made up of two individual units, which are called flights. And in my submission...
Sorry, you've lost me with this argument. You say the German version of the regulation uses the word flight.
Yes, my lord.
Unequivocally.
Yes, my lord.
Instead of depart.
Yes, my lord. So,
where is the German version of the regulation?
The German version of the regulation is... I apologise, it's in the other bundle at tab... 27, page 345. 545, apologies. 545. And I will again confess that my German not being brilliant.
Well, we'll get some help from Lord Justice
Of course.
Stuart-Smith in a moment.
Maybe.
You have there Article 3.1a.
Right. So, diese Verordnung gilt means this regulation applies for flights. Flugaster, flight? Is it?
I believe so, my lord. There is a translation in Sturgeon, I believe. I'm just going to find the reference for you and get that for you. So, my lord, it's Schenkel. It's the Advocate General's opinion in Schenkel, which can be found at page C77 of the authority bundle.
Sorry, just say that again. C what?
C77. So here you have an Advocate General 7. Most language versions use a construction similar to the phrase, this is talking about Article 3.1a, passengers departing from an airport, which appears in the English version of Article 3.1a and b. The German version, however, includes the word flight, rendering the phrase as passengers who embark on a flight at airports, which is, of course, where the relevance of this extended discussion of flight, which appears both in the Court of Justice's case law, but also...
Sorry, can we now go back to the so he says passengers who embark on a flight.
Yes, my lord. I presume, and again, I'm not really in a position to assist the court particularly with this, but that must be the Einen Flug antreten.
Well, ein Flug is a flight, isn't
Exactly, my lord.
it? And which page was it?
This is page C547. Page 547.
All right, so we've got a difference between passengers who embark on a flight and passengers departing from an airport.
My lord, yes.
Yeah?
And in my submission, those
If
two...
that's a difference.
Well, indeed, my lord, I'd submit that those two are in fact synonymous, and what the Court of Justice is doing here...
So we were looking at Wegener, weren't we?
We were looking at Wegener, my lord, yes.
You
so
were
that's-
making some point about the question of flights in Wegener.
Yes, my
I'm
lord.
not sure I've understood.
No, I appreciate that, my
If
lord.
these are synonymous, I don't understand what the difference is.
Well, my lord, I think the question is, in which circumstances does a passenger depart from an airport? Or, if you take the German version, in which circumstances does a passenger embark on a flight departing from an airport? In other words, is it only at the start of a series of connecting flights, and all subsequent flights taken within that series of connecting flights don't represent a departure from an airport? Or is it the case that every individual unit, flight, however you want to call it, of that series represents an individual departure?
Yes. And in Wegener, they said it was one.
Well, my lord, in Wegener, they said it was one for very specific purposes. And I'll come on to why, in my submission, that is the case.
Well, Article 3.1a has to mean the same.
Well, my lord,
You have to interpret the words of the article in the same way, whoever you are.
My lord, I accept that. My submission on Article 3.1a, in essence, is that Article 3.1a provides when the regulation can in principle apply. It clearly could in the case of Wegener, because there was a flight departing from an EU airport.
Well, it did apply,
Oh, absolutely, my lord.
because it was a single booking. So they couldn't say, oh, well, the second leg was nothing to do with us, because that left from Casablanca to Agadir and wasn't caught by the territorial gateway.
My lord, indeed.
And they said it was a single booking, so the airline was liable.
But my submission would be that had the facts of the case been different, and had been the second flight which had departed from the EU, which is the case in this case, it would nevertheless have been caught by the territorial
Well, that's a
gateway.
separate point. We're just looking at what Wegener says.
Well, my lord, yes.
And I think we've established that it makes no difference whether it talks about passengers who embark on a flight or passengers who depart. They said it's booked as a single unit, and that's what matters.
Yes, my lord, for the purposes of your right to compensation, absolutely.
Well, that's what they said.
I understand that.
They make 8 separate references to Article 3. I've not yet found a reference to Article 7.
No, my lord, although I will take you shortly to a case that does deal with Wegener in precisely the light of Article 7.
There's a chance reference in another case to what Wegener is doing. But as I say, in Wegener, there are 7 references to Article 3, not a single reference to Article 7.
I understand that, my lord, yes, and I completely accept that.
So where do we go, therefore, if Wegener is saying it's got to be, the airline can't get out of it because it's a single booking and you look at it as a single unit, it doesn't matter, does it, what the precise translation differences are?
Well, my lord, it matters insofar as the question is whether you can look at the individual components of a single booked transport.
Well, Wegener says you can't.
Well, Wegener says you can't for the purposes of establishing whether or not you're entitled to compensation for delay at arrival.
No, Wegener says you can't under Article 3, because Wegener is only concerned with Article 3.
Well, can we have a look at Wegener, please? Which page are we talking about? We're looking at the English version, are we?
Yes, my lord, at
345.
page C347.
Right. And which are the passages you rely on?
So, my lord, I've cited you paragraphs 8 and 12, which are the question referred, and I've taken you to paragraph 8 and 11, and I've taken you to paragraph 12, which, in my submission, draws this important distinction between the concept of a passenger transport operation, which is the entire of your trip, and the concept of an individual flight. And my lord, I'll come on to the relevance of that in the context of the case of Schenkel, which deals directly with this question of how far you can break down individual components of a flight when establishing whether or not a given trip falls within the ambit of Regulation 3. Article 3, apologies. But the point I wanted to deal with here, my lord, particularly, is this bit at paragraph 18, which is over the page at page C348. And the point made there, that it follows from the term last flight, that the concept of connecting flight must be understood as referring to two or more flights constituting a whole. Now, I accept, my lord, that there is some concept of a whole there. There must be for this case to make sense. But in my submission, it's necessary to take a further step and ask a whole what? And it's not, it's a whole air transport operation, which is different from, for the purposes of the German, a flight. So a passenger...
I'm terribly sorry. I'm sure it's my fault. I just don't understand this submission at all. Because Wegener is... You make the point that Wegener starts by treating them as separate flights, which is, you would expect, would be beneficial to your present argument.
Yes, ma'am.
But the decision is that the respective flights, whatever you like to call them, are to be treated as a whole. Where do you go from there?
So, my lord, where I go from there is to say that is really a question of whether a flight occurring outside the EU can somehow be brought within the scope of the regulation.
And the answer isn't.
The answer is
as
yes.
a separate item, it can't.
Well, the answer is as a separate item it can't, but that there are policy considerations justifying why this flight needs to be brought within the scope of the regulation.
If the passenger in Wegener had only wanted to go from Marrakesh to Agadir, the question wouldn't arise. Of course, it would only be that would be your unit, and so different questions would arise. What Wegener says is, you don't do that where you've got one aggregate unit, whatever word you care to use, however many flights or whatever word you choose to use there, it's one unit. Well, if that's what Wegener says, and if we don't disapprove Wegener, you lose, don't you?
Well, my lord, I don't quite agree with that submission for the simple reason that what I would say is happening here is you have the concept of one unit, but it's being used for a very different purpose. So there is a case, which I will come to in due course, a case of Boston, which deals with this point about how do you calculate distance when you're working out how much compensation someone is entitled to. And the answer the court gave in that case was you just look at the great circle distance directly between first point and last point. So in other words, you treat it as one unit for those purposes. But nevertheless, it could be made up of any route to get there. My submission, in essence, is that what Article 3 is doing is providing limits on the scope of the applicability of the regulation, which are set out really by international law. So Article 3 is there to make sure that the regulation doesn't tread on the toes of other countries, that it doesn't have an extraterritorial effect. And because of that, it applies only to carriers operated, EU carriers operating flights, because those fall within the EU's territorial jurisdiction by reason of personam, and carriers which have operated a flight in the course of a journey out of an EU airport. So that's what Article 3 is doing. It's saying these are the only circumstances in which we can justify imposing liability on a given carrier. And if you look at the case law in this case, if you look at the case law in Chesky, which I shall come to, then what the EU is doing, what the Court of Justice is doing there, is saying, notwithstanding that the actual delay happened outside the EU, there are grounds on which we can hold a carrier which did operate a flight out of the EU and therefore fell within the scope of the Article 3, fell within the regulation's territorial jurisdiction, liable. It's correct to hold it liable because the principles of passenger protection and the principles of equal treatment demand a passenger-friendly interpretation. And there's justification for doing so, in this case, because it was a single booking, so there's a single contract, and in the case of Chesky, because although the second flight was operated by a different carrier, because it had been arranged by the first carrier. So in other words, you're treating it as a single unit for the purposes of a passenger's right to compensation. But that is, in my submission, a different question to whether, in the first place, an air carrier could, in theory, fall within the ambit of the regulation. And for that, you just need to look at the natural wording of Article 3. You need to look at whether it has taken off from an EU airport.
Well, is your submission really, does it amount to this, that Wagoner was construing the regulation in a certain way so as to bring a claim within the scope of the regulation, and you say it should not be construed in the same way so as to exclude claims from the regulation?
My lord, that's certainly part of my submission, yes. And I'll come on to the principles I say lead to that conclusion, which are the principles of passenger protection and equal treatment. But it's also...
How does that work? I mean, if the words, only one set of words. I mean, there was a case, I think, called Oxfordshire Council, where Lord Hoffman said that the same words in the same statute could mean different things in succeeding sections. But I don't think he's ever said that the same words can mean different things in different cases.
My lord, I completely accept the force of that, and I'm not suggesting it should mean different things. I'm suggesting that if you look carefully, for example, at paragraph 25 of Wegener, which is the operative part of the judgment, you have...
Sorry, paragraph 25.
Paragraph 25, page C348, page 348.
Well, with EU decisions, you really do have to look at the operative words. So, paragraph 25.
It's repeated, of course, in the operative section after on these grounds at the bottom of the page. But...
So let me just read that. Taking account of all the aforementioned considerations, the answer to the question must be interpreted that Article 3.1a must be interpreted as meaning the regulation applies to a passenger transport effected under a single booking and comprising between its departure from an airport and its arrival at an airport a scheduled stopover outside the European Union with change of aircraft.
So the question is asked in terms of a flight, but they answer it to make it absolutely clear that it doesn't matter how many flights you've got, you look at one passenger transport starting and you look at where it starts.
Well, my lord...
How does that help you?
Well, so I'd suggest that helps me because the Court of Justice has very carefully drawn a distinction between the word flight and the word passenger transport. So it's using passenger transport to refer to this entire trip. For example, in the case of Schenkel, which I will take you to shortly, my lords, there was a question asked there about journey. So if you take off from an airport, go on a trip, you spend 2 weeks in New York and then you fly back, is that all one flight for the purposes of the regulation? The Court of Justice said in that case, no. You break that up into an outward leg and an inward leg. And what I'd say you've got here is a third step in between that. So you've got your individual takeoff and landing, your flight. You've got your entire trip out and your entire trip back, which is this passenger transport operation. It's an individual leg. And then you've then got the entire journey. Now, for the purposes of Article 3, the relevant bit is the departure or the flight from an individual airport. And as soon as you have taken off from any airport in the course of those series of connecting flights within the EU or within the UK, you are brought within the scope of the regulation. The question is then, was there a delay on arrival? And it doesn't matter where the delay occurred.
So that turns, I don't know if you're coming to it, on how you interpret depart.
Indeed, my lord, yes.
If I'm flying from Kansas City to Bengaluru, and I book that under one booking, somebody says, where are you departing from? I'd say Kansas City. Oh, I've got a stopover in London.
Well, my lord, I accept that, but I would also submit to you that if someone said, what time does your stopover flight depart, that would also be a perfectly natural meaning of the word.
Yeah, but because you've defined your departing by reference to your stopover flight.
I understand that.
So that doesn't help.
Well, my lord, the regulation doesn't define departure at all. The regulation only defines final destination and only uses the term flights loosely. My case
Well,
would
I
be...
suppose it helps you that the German version says passengers who embark on a flight at airport.
Well, indeed, my lord. Yes, and I would say that elucidates the natural meaning of the word
That's what
depart.
you're talking about,
Yes.
getting on a flight at an airport.
Yes, my lord. And if you were just taking the German version in this case, the natural meaning of that would be you fly from Berlin to Agadir, you stop at Casablanca, you do depart, you get on a flight at Casablanca to Agadir, and that flight leaves from Agadir Airport, or from Casablanca Airport.
But that would then lead to the opposite result. And there wasn't an opposite result because they said what mattered was it was affected under a single booking.
Well, my lord, yes, but
That seems to me to be the key point that we're in. I agree that now we've got the translation. Passengers who embark on a flight, that may be a wider meaning than depart. Because speaking for myself, I think depart means what I've just put to you. I'm departing from Kansas City with stopovers. But I agree that passengers who embark on a flight could be taken to be slightly wider. But that, since that was the question in Wegener, that might have led more obviously to the opposite result in Wegener. But it didn't because of the single booking, single unit point.
So, my lord, I'd respond to that in two parts. The first of which is to note, as I already have, that if you look at what the Court of Justice says in Wegener, it does draw this distinction between a flight, which I would submit is a flight for the purposes of the German and the regulation, and this broader concept of a passenger transport operation. And that's perfectly
None of that is relevant to the decision. Effected under a single booking. That's the key bit.
And my lord, that would be the second point I'd come to, which is that if you look at why the affected under a single booking matters, it's because it's a mechanism by which the Court of Justice was able to impose liability for the second flight.
Well, that's not fair, is it? It is a single booking, and because in that case it met the territorial gateway, it was the responsibility of the original carrier.
But my lord,
So that's not a mechanism. That seems to me to be common sense. Why should the airline get out of liability because the second leg, which it had arranged, was actually operated by somebody else?
Well, my
it's
lord,
effectively passing on liability to a subcontractor, although you had, under your contract, you had accepted liability for X. You said, well, actually, I'm not liable because it was done by a subcontractor.
I completely accept that, my lord, and that is the issue in the case of Chesky, which the respondents also rely on, where the second flight was operated by a different airline, and so the first airline could be held liable. But the point I'm trying to make is that there are two separate questions under consideration, and the first is whether the regulation could in theory apply to a given airline in respect of a given journey, and the second is whether, in practice, it does apply to grant compensation. And I will come on to the detail of that, if I may.
Well, I mean, I suppose you say that the regulation has to be given a purposive construction. And you say a purposive construction is one that is inclusive for the purposes of making the regulation apply and granting compensation. And to construe the words departing on a flight at an airport as meaning only departing on your first of 4 flights, which may be long time apart, is wrong. But then you've got a very hard job, as it seems to me, in understanding what they were doing in Wegener, where they were obviously trying very, very hard to construe the regulation to make the airline liable in that case for flights leaving from airports outside the EU. And at the moment, I just find it quite hard to reconcile the two. I mean, there is an element of tremendous injustice, actually, because you arguably might say your construction is better, and they were trying too hard in Wegener, and if you were going to have a single construction, your construction is better, and that would exclude Wegener and include you.
Which would, of course, my lord, be the essence of my second point, my second ground of appeal.
Okay, that would be the essence of your second point, but at the moment you're trying to square a circle. And you're, for me anyway, you're going to need to formulate in very clear words the argument that you made several times, which is you're just construing the meaning of Article 3.1a and therefore something. And I haven't got the something yet.
I understand that, my lord.
I get you're just construing the meaning of Article 3.1a. How do you then say you square Wegener? In very slow language so that the judges can understand.
So, my lord, the way you would say that, I think, is as follows. First of all, you've got my point, I believe, that Article 3.1a, as read naturally, or as I would submit, as read naturally,
that's
covers
the
that.
first point. That's the second point I want.
The second point is really that there is, I'm trying to think of the best way to phrase this, my lord, to try and keep it as clear as possible. It's really that you've got two separate questions. You've got the first point, and then you've got this second point, which is, in what circumstances is it, as a matter of principle, fair to hold an air carrier liable for delay on arrival? The difficulty is that these words aren't coming from the regulation themselves. They're the result of interpretations and interpolations by the Court of Justice. So the key point that the Court of Justice has made is that the relevant delay is delay on arrival, not on departure, because that represents the inconvenience suffered by passengers. So you have a situation where if passengers suffer delay on arrival, but that delay occurred outside the EU, the passengers haven't suffered any less inconvenience than they would have done otherwise. And so, in the Court of Justice's view, you have to find a way of holding an airline, the airline that falls within the territorial scope of Article 3.1a, liable if you can. In Wegener, the mechanism for doing that is this single booking. It's that there is a contract for the entire trip from point A to point C. In my case, it's a different approach. You're instead saying, well, Article 3.1a applies because a passenger departed from an EU airport. It embarked on a flight departing from an EU airport. And so you look at the delay on arrival, which was caused by delay on this flight departing from Heathrow, and you say, is it just that the passenger should be entitled to compensation given the requirement to read the regulation purposefully? It is, and it is perfectly acceptable to impose liability because there's no territorial issue with doing so, and therefore you should impose liability. And the way I get to that point is by saying that in Wegener, the Court of Justice is concerned with two separate issues. And I believe, my lord, that this is much clearer, in my view, in Chesky, which I would submit to your lordships is...
Right, where's that?
So, my lords, I'll take you to that now. That is at tab...
355.
Yes.
C355.
C355. Thank you, my lord. My lord, if I just take you to the, first of all, to the summary of the case at page C355. You have the passengers booked flights. The first flight, operated by the defendant, arrived at its destination on time. However, the second flight, operated by a non-European Union carrier, arrived at the final destination over 8 hours late. In other words, the delay incurred entirely on the second flight outside the European Union. The passengers claimed compensation from the defendant under Article 5.1c. So this is the article that deals with compensation for cancellation, but has been extended by the Court of Justice to apply to compensation for delay. And the court held that even though the defendant airline had not performed the flight which had been subject to the delay, it was liable by virtue of Article 3.5. And I'd note, my lord, that there is no reference there to Article 3.1a. The court isn't relying on Article 3.1a for the point made. And if I could take your lordships to the operative part of the judgment, which is at page 361, paragraph 33. You can see that how the court has framed this issue here is that the answer to the question referred is that Article 5.1c and Article 7.1 of the regulation, read together with Article 3.5 of that regulation, must be interpreted as meaning that in the case of connecting flights, where there are two flights that are the subject of a single reservation, departing from an airport located in the territory of a member state and travelling to an airport located in a non-member state, via the airport of another non-member state, a passenger who suffers delay, the cause of that delay arising in a second flight operated under a code share agreement, may bring his or her action for compensation under that regulation against the community air carrier that performed the first flight. And what I would submit to your lordships is that this represents the Court of Justice refining its approach in Wegener. And it's no longer... Refining.
Where do we get that from?
My lord, I'm not suggesting that there is anything specifically in the case to suggest that, but there are references to Wegener. So, for
it's
example...
a completely different formulation from Wegener.
Indeed, my lord, yes.
And it's saying that this result originates not from the construction of Article 3, but from the construction, or not from Article 3.1a, but from the construction of 3.5. What do these three regulations say? 5.1c, Article 7.1, and 5.3.5.
So, my lord, if I could take you to page...
Well, they're set out in the judgment.
Yes, my lord.
And they are referring to Article 3.1.
Well, they are...
That's at paragraph 4, 3.1 and 3.5.
Well, my lord, I absolutely wouldn't dispute that 3.1 must be of relevance, because if 3.1 isn't triggered in the first place by something in the series of connecting flights, then obviously the regulation can't apply. I don't think there'll be any dispute from our perspective about that. But my submission is that the Court of Justice is going further in this case and looking at how exactly it works. So Article 3.1.5 states that the regulation shall apply to any operating air carrier providing transport to passengers covered by paragraphs 1 and 2. So where an operating air carrier which has no contract with a passenger performs obligations under this regulation, it should be regarded as doing so on behalf of the person having a contract with that passenger, which is a perfectly logical way of approaching it. It imposes a contractual obligation on airlines for transport that they have organised. And my lord, that is very similar to the case in Wegener, although I completely accept that there are differences in the facts and that this is operated by a different airline here. But then...
So which was the other article?
And then there's Article 5.1c, which deals with cancellation of a flight, which has been interpreted by the Court of Justice to include delay of more than a certain length of time. And then there's Article 7.1, which is at the bottom of page 357.
So going back to, I mean, it seems that Article 3.5 is the most significant, isn't it?
Yes, my lord.
Because that says that this regulation, I mean, that first of all, that's jurisdictional. And it says, shall apply to any operating air carrier providing transport to passengers departing from airports in the member state. So it goes beyond, and they construe that down at 33. Where's the question?
The question, my lord, is at paragraph 14, page 359.
So the question was under 3.5, interestingly.
And I think, my lord, the point I'd make is that there was no need for 3.5 in Wegener because the same air carrier was operating both flights, but that this would have provided, in essence, the same mechanism for doing this. The point isn't reliance, per se, on Article 3.1a or 3.1b. That brings an airline within the jurisdiction of the regulation. But the point in Wegener is really the emphasis on the fact that there is one contract means that for the purposes of compensation, and I stress for the purposes of compensation, this article should be, the flight should be regarded, the trip should be regarded as a whole.
So the answer to my question, really, is that the reason why you say Wegener can be distinguished is if you're right about the natural meaning and purposive construction of 3.1a, Wegener can be explained, and the CJEU did effectively explain it by saying it's really a construction of Article 3.5. You don't need 3.1a. Maybe they put it on 3.1a, but they, as usual with the way the CJEU develops its case law, it sort of makes mistakes and then corrects them, and that's what really happened. And if that's the case, you don't need to have a construction of 3.1a that is really forced and wrong.
Well, indeed, my lord. And there's nothing inconsistent in my submission about treating the entirety of the appellant's flight, in this case, as a unit for the purposes of compensation from start to finish, but saying that it nevertheless fell within the ambit of the regulation because, on the wording of the regulation alone, it fell within that scope. A flight departed from an airport in the UK.
Yeah, well, I see the point. Yeah.
And my lord, that really is the essence of my submissions on this point.
Well, it's the beginning and the end of the case in one sense, but in another, you need to show me anyway why you say that the regulation ought to be construed in an inclusive and broad way, in a purposive way. So is there authority that says we're trying to make carriers liable for as much as possible?
Well, absolutely, my lord. And that was the point I'm going to come on to next. So I wanted first of all to explain my reasoning for why this isn't an issue in terms of the construction of it, and then secondly deal with this broader point about the policy principles that lead to this conclusion.
I mean, is there's a third case, isn't there? Does that help?
There's OI, my lord. In my submission, and I accept that my learned friend may take a different view to me on this, OI doesn't add a huge amount to Chesky and to Wegener. So that's at page 391 starting. And that was dealing with a slightly different issue. It was dealing with a rebooking of flight. But I submit that really where the question comes in is that at paragraph 26, the court uses the formulation of the issue that it's also used in Chesky, where it says...
Page which again?
Sorry, this is page 396. Apologies, my lord.
Right. 396.
Page 396, paragraph 26, just after F. And that's really just repeating what the Court of Justice has said in Chesky.
Well, yes, but importantly, saying that it constitutes a whole, not for the purposes of Article 3(1)(a), but a whole for the purposes of the right to compensation for passengers provided for by regulation.
Well, indeed, my lord, and that is exactly the formulation also used in Chesky at paragraph 16.
Yes.
And then at paragraph 34, which provides the operative part of the judgment for this first question, the court says, in light of all the foregoing, this is page 397 over the page.
Sorry, which paragraph?
Paragraph 34. The answer to the first question is that Regulation 26104, and in particular Article 7 thereof, and I note the focus on Article 7, must be interpreted as meaning that compensation is not payable to a passenger who had a single reservation for connecting flights in the case where that reservation was amended against the passenger's will, with the result that they didn't board the first of their reserved flights, even though that flight went ahead, and second, the passenger was given a seat on a later flight which allowed him or her to board the second of his reserved flights and thus reach his or her final destination at the arrival time originally scheduled. So in other words, the passenger experienced no delay and they arrived on time, so there's no compensation.
Not right. Passenger did experience delay on the first part of the flight.
Sorry,
on the first flight. She didn't experience delay overall. So you look at it as an overall booking and the claim failed. If you're right, that claim would have succeeded because it would have been a claim that whereby the first flight, and you break them down for the purposes of compensation, you say, was late.
my lord, that's not quite what I'm saying, in the sense that I fully accept that the Court of Justice has said that the delay is delay on arrival at final destination. So it has to be, that's the inconvenience suffered. If a flight is, if you had a series of connecting flights entirely within the European Union, so this wasn't an issue at all, and you had a delay on your first flight, but your final flight arrived on time, regardless of that delay, you still wouldn't be entitled to compensation.
Well, that's what OI says, because you're looking at it as a whole, not breaking it down individually.
Well, my lord, my submission would be that you're looking at it as a whole for the purposes of compensation,
Well,
not for the purpose of...
but
Yeah, you say that.
you made that point.
Yeah.
You say jurisdiction is each flight and compensation is the whole journey.
Well, exactly, my lord, yes. So, my lord, I think that that would be a sensible place, unless I can assist your lordships further, to leave those submissions on the interpretation of the regulation itself and move on to the points of principle. And
I mean, what you have to say really is that, and this may affect your second point, but you have to say that the European Court doesn't really look at things in the way we do, in the way my lord is looking at it, which is as a common lawyer saying we need a common law construction of these words, and but it looks at it as a more purposive exercise, and it's saying that, as I put to you just a minute ago, for jurisdiction, you get into it if you leave any flight in the EU, or I suppose arrive, I think it's leaving, isn't it? And for compensation, you look more generally to see if you've suffered the loss because of the delay overall. And that does make quite a bit of sense.
well, indeed, my lord, and my submissions earlier, and I fully accept that this is a potentially very confusing issue, were attempting to demonstrate that even if you do take quite a rigorous common law approach, there are ways of looking at how the Court of Justice has defined this that can, in my submission, square that circle, although I accept that it's not an easy thing to do. Court of Justice decisions are always tricky in this regard.
Well, and it does raise a rather more an interesting question of how are we going to construe EU decisions post-Brexit?
Well, indeed, my lord.
Are we going to struggle to, because we're not bound by the Court of Justice anymore, are we going to apply the more rigorous common law approach to construction of legislation that comes to us through the EU?
And my lord, I think on that point, it would make some sense to deal with the provisions of the EU Withdrawal Act, which do address this point.
Right.
So if I could take you, my lord, to page 526 in the bundle at 24. And then at page 528, we have this section dealing with interpretation of retained EU law. There's obviously a point of paragraph 1, which is relevant to my second submission, my second ground of appeal, that a court or tribunal, including this court, is not bound by... sorry, that's not the wrong passage, I'll come on to that. But then the paragraph 3, sorry, section 3, subsection 3, page 529, states that any question...
Sorry, you lost me completely.
Apologies, my lord.
Which section are you in?
Section 6, subsection 3,
Okay.
page 529.
Yeah.
And the point here that any question...
questions, the validity, meaning or effect of any retained EU law is to be decided as far as that law is unmodified on or after exit day. Well, this is going to be modified, right?
Well, my lord, I submit that there is a question about what modified means and whether it means substantively modified, or whether it means just... Because almost all EU law at this point will be modified to some degree to bring it in line with the requirements of EU law, UK law. It wouldn't make sense for the regulation to apply to flights departing from an EU airport at this stage, going forwards. But I would submit that this law is unmodified in any substantive sense. There haven't been any substantive changes to the regulation. And in my submission, my lord, that must be what Article 3 is getting at. Because Article 3 can't mean that there haven't been any changes at all, because almost everything will have been changed to some degree.
So in other words, we're to apply retained case law, which we've been debating, and retain general principles. What's that, equivalence and...
Well, it's equivalence, but it's also, in my submission, the principles of passenger protection and consumer protection and equal treatment, which, as I will take your lordships to, have been repeatedly stressed in the context of this regulation by the Court of Justice as the key principles to interpreting it.
What do you call the principle? The one that you...
Oh, I'd call it the principles of consumer protection, or as the courts call it, passenger protection in this case. But consumer protection is the broader principle of EU law, and equal treatment. Equal treatment and non-discrimination, if you want the precise terminology.
Yeah.
My lord, if I could take you first. I'm going to first deal with the principle of passenger protection, consumer protection.
Well, as to that,
Of course, my lord.
maybe we can short circuit. If you go to Lipton,
Yes, my lord. Tab 17. Sorry, page 399.
yeah, there is somewhere in the judgment, is there not?
There is, my lord. I believe it's paragraphs 83 to 80.
No, I wasn't in that bit of the judgment. Yeah, paragraph 12, so page C403.
Yes, my lord. Yeah.
I cite Wallentine Herman, a high level of protection for passengers, and Sturgeon, that you look at it not from the air carrier's perspective, but from the perspective of the passenger.
Absolutely, my lord. And
As a summary, is there anything else?
but there are a couple of other points I want to deal with specifically in response to points made by my learned friend, which I'll come to in due
But
course.
you accept that paragraph 12, even for a common lawyer, is a summary of the first principle you're talking about.
Absolutely, my lord. I'd also note that there is a point made, and I'll just find the reference in Lipton, to the trade and cooperation agreement between the EU and the UK, and that is at paragraph 73, page 418.
Where are we? 73?
Yes, page 418. And this is specifically in the context of consumer protection in the case of denied boarding, cancellation or delays. And the UK and the EU have signed a treaty provision stating that the parties share the objective of achieving a high level of consumer protection, and that the parties shall ensure that effective and non-discriminatory measures are taken to protect the interests of consumers in air transport.
That's between the UK
And the EU.
EU,
Yes, my lord.
not between the USA and India.
No, indeed, my lord, indeed. And I completely accept, my lord, that had this flight never gone anywhere near the EU or the UK, this wouldn't be an issue for consideration in the slightest.
Does your construction abrogate the any possible argument about how long people stay over?
I think, my lord, there would be an interesting argument you could have about whether a flight was a directly connecting flight. It's not, I understand, to be an issue in this case at all.
I mean, directly connecting flight is not a term of art.
No, indeed, my lord. There might come a point at which you would, let's say that you took a trip from Kansas to Bengaluru, but you stayed for a week in London. There might be a point at which that is two separate transport operations for the purposes of compensation. If that makes sense.
Well, I find it rather difficult because it seems to me that they obviously are two separate transport operations.
Well, indeed, my
But I
lord.
mean, it's obvious if it's a week, it's not obvious if it's a night.
Yes, and I think this is the Court of Justice's emphasis on the term stopover. But it's not an easy question to answer. I completely accept that. I don't think that there's any dispute in this case as to the fact that the flights were directly
Is there any
connected.
relevance of the decision in Lipton to our case?
No, I don't believe, other than the principles elucidated in Lipton, that there's any specific relevance. That case was concerned with passenger sickness. I believe my lord was on the panel in that case, and it was not passenger sickness, aircrew sickness.
Yes.
Yes,
The captain was ill,
indeed.
and the argument was, well, the captain became ill on his own time, and therefore that's an extraordinary circumstance. And the court took a different view.
And I might add that, speaking as somebody who has argued that in the county courts, it's very helpful to have a judgment saying which is correct. But,
And where are the principles that you say apply?
so my lord, there's the principles of passenger protection that's been referred to, but there's also a helpful summary at paragraph, I believe it's paragraph 83 of the judgment, which is at page C421 following. And that just runs through how one should interpret the regulation post-Brexit. Lord Justice Green's judgment. And so it says, the regulation is direct EU legislation. It takes effect in domestic law as amended, which is obviously the issue we discussed earlier, my lord. It should be given a purposive construction, which takes into account its recital, which deals with the principles of passenger protection, and other principles referred to in the body of the regulation and in the recitals. To the extent necessary, this process of interpretation would include any provision of international law that's been included by reference, which includes the Trade and Cooperation Agreement. The meaning and effect of the measure should be determined by reference to case law of the CJEU made prior to 11 p.m. on 31st of December 2020. General principles of EU law from case law and as derived from the Charter of Fundamental Rights and the Treaty on the Functioning of the European Union are relevant to interpretation. And in construing and applying such a regulation, which is my second ground, the court can depart from any retained CJEU case law or any retained general principles. The court is not bound by such principles and may depart from them if it considers right to do so. And then you've got the point about the Trade and Cooperation Agreement directly, subparagraph 9. The point noted there at paragraph 84, which I'd submit is very similar in this case, is that none of the principles caused any difficulty.
I don't know why we set them out, but anyway, there we are.
Well, my lord, I think it's certainly from my perspective helpful to have a summary of what the court thinks is the relevant approach to it, but I accept that.
When we try and decide cases according to the issues that arise in them rather than giving guidance for future cases, we can't imagine what their facts might be. But anyway.
Well, indeed, my lord. My lord, I wanted to note just a couple of points specifically on the principle of passenger protection.
Yes.
So the first is that if I could take you to page 196 of the bundle, which is the case of Sturgeon. You have a statement there, at paragraph 45, that the provisions conferring rights on air passengers, including those conferring a right to compensation, must be interpreted broadly. And then at paragraph 49, further down the page, in view of the objective of Regulation 261/2004, which is to strengthen protection for air passengers by redressing damage suffered to them during air travel, situations covered by the regulation must be compared, in particular, by reference to the type and extent of the various types of inconvenience and damage suffered by the passengers concerned. And then it quotes the case of IATA and ELFAA. And then, my lords, I just wanted to take you further on in Sturgeon at page 198 to paragraphs 167 and 67 and paragraph 68, which my learned friend places some emphasis on. And paragraph 67, in particular, states that said, it should be recalled that, with the adoption of Regulation 261/04, the legislature was also seeking to strike a balance between the interests of air passengers and those of air carriers. My lord, this is relied on by the respondent, as it so often is in cases of this nature, to demonstrate that the balance goes both ways, and that you have to also take into account the interests of air carriers.
Well, if it's an argument about extraordinary circumstances, you do.
Indeed, my lord.
But this isn't an argument about extraordinary circumstances.
And that was precisely the point I was going to make, my lord. So you have in paragraph 67 the point about extraordinary circumstances, and in paragraph 68 you have the point about the air carrier's right to claim compensation from third parties who might be liable for the delay. That is the balance, in my submission, which is offered to airlines. They can get their money back if they're not liable, and they don't have to pay if it's caused by extraordinary circumstances. There's no need to look further than that for principles of airline protection. And that, my lords, is also reflected in the paragraph at IATA at 90 and 91. But I won't take your lordships to that for reasons of time. Then,
I don't understand where this goes, though. If you're right about Article 3 and your view of Wegener, then you say this doesn't arise. So in what circumstances could the principle, you accept, I think, that the principle can't trump the article. If we were against you on your, how you interpret Article 3.
my lord, I'd accept that the principle can't trump the article, but I would submit, first of all, that the principle could lead your lordships to take a different view of Wegener, or to override Wegener, if they considered it inappropriate interpretation. That's my second ground of appeal.
That's your
so it is, of course, relevant.
I see that it goes to that.
And
the slight difficulty with that is that Wegener's been, it can't be regarded as a maverick decision. It's been followed hither and yon.
And secondly, my lord, the other point I'd make is that insofar as your lordships consider that the interpretation I've proposed for Wegener is plausible but perhaps a bit of a stretch, my argument would be, well, these principles would encourage your lordships to interpret this regulation purposefully and to read Wegener purposively in light of that. So in other words, it is relevant in circumstances where, as my lord said, you need a little more persuading.
I mean, there is a bit of a problem. There's a bit of a problem, really, with this situation we're in now, because we know that the CJEU very often revisits decisions like Wegener and says, oh, we didn't really mean it was construction of Article 3. It's obvious from the subsequent cases that we really meant it was the construction of Article 3.5, not 3.1. But we can't refer, you know, this would be a classic case where we would, we would refer and say, what did you mean? We can't understand. We're not sure. you know, Wegener doesn't look as if it's completely on all fours with Chesky, right?
Yes.
And they'd come back and say what they did, or normally unintelligibly, but sometimes intelligibly. But we can't do that now. So we've got to do the best we can. And the irony is we're applying principles that are foreign to our own legal principles in order to do that. And we're told we have to by the Withdrawal Act. So, and it seems to me anyway that this does give rise to the potential for us disagreeing with the CJEU in the future, even if we didn't want to.
I completely agree, my lord.
Because we decide as we want to, and they'll decide as they want to, and it's unlikely they'll pay much attention to what we've decided on their decisions.
Yes, my lord, and it is a acknowledged complication, I will say, perhaps, of the legal structure that the government has adopted in departing from the EU, in that there will be divergence over time, potentially, if the Supreme Court disagrees with Court of Justice decisions.
Yeah.
And I would note in that regard, my lord, that one of the issues with Court of Justice judgments, particularly as a European lawyer, is that they very rarely say if they disagree with previous judgment. They tend to...
No, they don't. That's
They
quite
never say.
Well, indeed, yes.
Never.
Never.
I've never seen a case. I mean, they just cite the cases that support. I mean, very often they ignore the cases that come to a different conclusion to the one they want to come to.
Well, exactly, my lord.
But they do sometimes say, you know, Wegener must be interpreted as meaning something completely different from what Wegener said. But, you know, it's the formulation of wording that is so wonderful. You know, they must be interpreted as meaning when it doesn't mean that. And this is where the common law versus purposive construction point really comes in. And that's where we are in this case. Are there any, I mean, I know you cite tuning. I think I had some quite strong things to say, but are there any other cases where this has come up yet?
I don't believe, my lord. Certainly I had a quick look when I was trying to put the authorities bundle together to find anything where the courts had departed from a position in EU law, and I couldn't find anything.
I don't mean that. I mean where they've been faced with a common law versus EU type construction.
I'm not aware of anything, my lord.
Well,
There may well be cases, but this is... I mean, there certainly will be going forwards, I'd suggest, regardless of...
it sounds like this is one.
Indeed, my lord. And I think that one of the fascinating things about this regulation is it has already caused European lawyers considerable amounts of post-Brexit stress, in that we now have a view expressed by this court on which regulation you apply. And we now have an issue where there is a potential conflict, as your lordship quite rightly says, between the provisions, the approach taken by the CJEU and between the common law. And this regulation is much litigated, and I imagine might lead to more issues.
Well, I mean, there are massive commercial consequences, if you're right.
Well, indeed, my lord, yes.
Because these claims are legion.
Yes. And I think, certainly from my perspective, one of the key points, speaking as a lawyer, would be to have certainty on these issues, regardless of what the outcome of that would be, because that does help these cases settle or get resolved quickly and cleanly.
But imagine the situation if we decide one way and the CJEU decides the other.
Well, my lord, in those circumstances, I'd submit that the position in UK law would be very clear.
I mean, this case that you took us to, Air Help, obviously looks as if it comes within 3.1b.
Indeed, my lord.
But we need a translation of that, I think.
I agree.
In order to be sure that it doesn't say anything about what Wegener may really have said. I looked at the two paragraphs that mentioned Wegener, but it didn't seem to be very meaningful. But I really would like to see it in English.
Of course, my lord. I will do my best to get that to you.
I mean, there's no official translation.
There's none that we could find, my lord. So on the Court of Justice website, there is only the other language versions, which don't include the English. Why that is, I don't know. But sometimes that is just the case with these sorts of decisions. So My Lord, there was only really one further point I wished to make on the principle of passenger protection, and that's to take you to page 211 of the authorities bundle in the case of Air France and Focus. And the point made at paragraph 46 there. Which is this point that, lastly, in any event, the case law shows that the importance of the objective of consumer protection, which therefore includes the protection of air passengers, may justify even substantial negative economic consequences for certain economic operators. So in other words, strong words from the Court of Justice, which is saying you really do look at this from the perspective of passengers and consider the inconvenience that passengers are suffering. So those, my Lord, are really the submissions on the principle of passenger protection, which are relatively straightforward and are in any event set out at paragraphs 19 to 27 of my skeleton argument, in case it would assist your lordships to consider anything further instances I cite.
Is there any law, EU law, about protecting non-EU citizens? I mean, this strikes me as a charter. I don't mean that derogatively, but as a charter for the protection of non-EU citizens who happen to travel through the EU, maybe fortuitously, where one might wonder whether the principles of consumer protection, which presumably apply to one's own citizens, member states' citizens, would be meant to apply. Is there anything in the CJU which says we apply the same principles of consumer protection to everybody, because that's non-discrimination?
My Lord, I don't believe there is. I had a look at an issue similar to this in the context of the case of Verano, which appears also in the bundle. And as far as I'm aware, it is not an issue the Court of Justice has ever grappled with. Now, my case on this would be that at no point in the relevant provisions of the treaty or in the provisions of the TCA or any of the other provisions of the recital to the regulation does the EU say, does the legislature say, we're only concerned with EU citizens here. It says consumer protection, it says passenger protection. And there is, in my submission, no clear reason why it would be justified to treat non-EU consumers different from EU consumers in circumstances where they otherwise fell within the scope of the regulation. So, for example, if the appellant in this case were a EU citizen who happened to be travelling from Kansas to Bengaluru, their position could be, under your lordship's argument,
probably EU citizens do make that journey less often than American or Indian citizens.
Well, indeed, my lord, and I do accept that
make
point.
all journeys. I mean, the point is what we're really doing is applying the protection to all comers. And the EU is a massive airline hub. I mean, obviously, we're not deciding EU law, but even so, we are saying this is how the Court of Justice would decide it for anybody, and where you are passing. I suppose it applies. I suppose the situation applies equally. I mean, so what happens to a flight that goes from Kansas to London, Kansas to Paris? Is that covered by 31A? No.
Kansas to Paris, my lord.
Yes.
It would be covered by 31A in circumstance where it's a community carrier, because it would fall within 31B. So, no, sorry, it wouldn't fall within 31A.
31B.
It would fall within 31B potentially if there was
Only
a
if
community
it's
carrier.
a community carrier. Yeah. If it's not a community carrier, I'm just thinking of the ramifications. So it is only people who start outside the EU and end outside the EU, but depart from an airport within the EU on the way. So the sort of classic New York, London, Singapore. That
And in my submission, my lord, that must be because if you look at the operation of 31B, 31A and 31B, which was considered at some length in the cases of Gahan and Verano, which are in the authorities bundle, it's concerned with the territorial scope of the regulation. And for whatever reason, the EU has decided that it wouldn't be justified to impose its jurisdiction on airlines landing in the EU, but it's perfectly okay to impose its jurisdiction on airlines operating out of the EU. I understand the logic for that being that by operating a flight out of the EU, the airlines are taken to have submitted to the EU's territorial jurisdiction. But I accept that this isn't an easy question at all, and it's been the subject of considerable argument in the past.
Because in this case, if the stopover had been in Geneva, there wouldn't be a claim.
No, indeed, my lord.
And so, if there had been a problem with the flight and it couldn't land at Heathrow and it went on to Geneva, then there wouldn't be a claim. And it then becomes, potentially at any rate, a bit of a lucky dip.
Well, my lord,
for non-EU citizens flying not from the EU to a destination not in the EU, it is a bit of a opportunistic lottery.
my lord, what I would submit in response to that is that the same logic would apply to a series of connecting flights operated by an EU air carrier that was supposed to land in the EU, but in fact was forced to divert to Geneva.
I think air carriers are completely different.
Well, I accept that, my lord, but...
I mean, I'm just on the territorial point, the territorial gateway, it's slightly uncomfortable because you are getting into... I mean, I appreciate you have your principles, and I understand those, but it's a bit opportunistic as to whether those principles can be relied on, depending on where the stopover was.
My lord, the reason I mentioned 3.1b is because that also has a territorial gateway. So although it is concerned with air carriers, it nevertheless says they have to land or take off from an EU airport.
Well, what's the answer to my question?
So, my
You
lord,
accept that it would give rise to at least a lottery element.
my lord, I would accept that there is always a risk of that, yes. And I think that however your lordships slice this regulation, however your lordships choose to interpret the regulation, there will be potential strange consequences to this. And that's what was noted by Lady Justice Arden
In Gahan.
in Gahan.
Yeah.
And while I would obviously submit that Lady Justice Arden's specific reasoning in that case was wrong, and she hadn't heard argument on that point, nevertheless, the same principle does apply, which is that provided that one takes a rigorous and, as you say, common law approach to this, that there may well be inconsistencies in the regulation. The Court of Justice has historically, as my lord has stated, solved this by a very, very purposive approach, where it has tried to find the right outcome wherever it possibly can, or what it considers to be the right outcome. But I do accept the possibility for inconsistency.
Well, it's not just a possibility, it's an inevitability.
Well, I think, my lord, that's correct, and I think that's correct no matter how the regulation is interpreted.
Can we just look at 3.1b?
Yes, my lord, it's page 20, sorry, not page 20. It's page 503, tab 20. No, 505.
Because you may get some help, may you? So the regulation applies to passengers departing from an airport, same expression. Presumably in the German version, it applies to
Passengers departing on a flight. I
flight.
believe that is correct, but I will check that point.
located in a third country to an airport situated in the member state, unless they received compensation in that third country. If it's a community carrier. And has that been interpreted as meaning a series of flights?
That I understand, my lord, and I could well be wrong about that. That point hasn't been dealt with that point hasn't been dealt with directly anyway, and in the case law that we've got before us. the closest that comes, as my lord has noted, in the recent CJA judgment, where it is a community carrier. I will have a look over the lunch break to see if there are any references to this point in any other case law, but I don't believe that there are from memory.
Well, I mean, if that would be completely illogical. So if you fly from Los Angeles to New York and New York to London, and the delay is on the New York to London leg, and you're knocked out, I suppose that doesn't work. I'm trying to think of when it would come up. But you construe passenger departing from an airport. You don't need to construe it, even if you've got several legs outside the EU.
No, my lord, because while delay on those legs might be relevant insofar as you arrived at your final destination late, and insofar as the airline was actually responsible in some way for that delay, it wouldn't be... So I put it this way, I can imagine a circumstance in which you had different airlines with which you had different contracts operating each leg of the flight. You wouldn't in those circumstances, I think, be entitled to take into account the delay on a flight that was operated by an airline that never came within the territorial ambit of the EU in any way, of the regulation. But if you've got a single booking, for example, with a carrier who has organised this whole series of flights, then at that point you can take into account delay, because the relevant delay is the inconvenience that you as the passenger suffer when you arrive at your final destination. You don't particularly care if your stopover is delayed if you still get there on time. And that's the point the Court of Justice has made.
No, I'm more interested in the words to passengers departing from an airport in both 1A and 1B. They must be the same.
I agree, my lord, yes. But I'm struggling to think what circumstances there could be a distinction between 1A and 1B in that regard, because arguably that the words departing from an airport in 1B are unnecessary, because a community air carrier would also fall within 1A if it was departing from an airport. I think it could just be there for completeness' sake.
No, I mean, it's an airport located in the third country in B.
Oh, sorry, yes, my lord. You're quite right. Yes, because it does, yes, so, sorry, my lord, you're absolutely right, I was misreading this. But the point being that then you have 1A, which deals with situations where you depart from the EU airport, and 1B that deals with situations where you arrive at an EU airport.
Yeah, okay.
Thank you, my lord. So, I think, my lord, that deals with the principle of passenger protection. And I just wanted to deal briefly with the issue of equal treatment, which I think your lordships have already raised some difficulties with this, and I do accept that this is a principle that does cause issues in these cases. And if I could take your lordships, first of all, to page 196 of the bundle, and paragraphs 48 to 49 of the case of Sturgeon. And I cite this because here the Court of Justice just sets out, neatly encapsulates what the principle of equal treatment actually means. And it states that the principle of equal treatment requires, this is paragraph 48, comparable situations not to be treated differently, and that different situations must not be treated in the same way unless such treatment is objectively justified. And at paragraph 49, in view of the passenger protection objective, situations covered by the regulation must be compared, in particular, by reference to the type and extent of the various types of inconvenience and damage suffered by the passengers concerned.
What does that actually mean?
Well, my lord, what this means is that when you are looking at the non-discrimination provisions, you look at it from the point of view of the passengers rather than from the point of view of the airlines. And the reason that is relevant is from the case of IATA, which is at the bundle at tab find the exact reference. No, that's tab 2. Apologies, my lords. You hadn't the page numbers. So that is at page...
Which
Apologies, my
paragraph?
lords. I just need to find the relevant section, which I have completely lost among all my documents. And the issue in this case was that the airlines said, in essence, it's not fair because we are being treated differently to community carriers operating low-cost flights and to passengers operating different transport provisions.
Yeah, this was the low-cost airlines
Judicial review.
judicial
Yeah.
review.
And the approach taken by the court, and I do apologise, I appear to have
Is
completely...
it page 69?
It may well be, my lord,
June?
yes. Yes. So this is the point about passenger protection. So it says, in assessing whether the measures are necessary at paragraph 82, it should be noted that the immediate objective, as apparent from the first 4 recitals, is to strengthen protection for passengers who suffer cancellation of or long delays to flights. The point being, and I will find you the exact reference, my lords, is that when the court was looking at this issue, it faced the argument that you should look at the relative situations of airlines compared to other operators of transport. And its response to that was to say, no, you don't do that. You look at the position of passengers.
You're already doing that because of the high protection.
Well, indeed,
consumer
my lord.
thing. So that it's not at the moment. Speaking for myself, I can't see what this is adding to
Well, my lord,
my brilliant one-paragraph summary in Lipton that you look at it from the passenger's perspective.
absolutely, my lord. And the only thing I wanted to add with that is just to show how it works in practice. And I think you have that in Schenkel, which is at page 90, at paragraphs 37 to 38.
Wow.
And I just cite this to demonstrate how this principle of equal treatment, which I completely accept, my lord, is very, very similar in practice to the principle of protection for passengers. But what the principle of equal treatment says is that if you have 2 passengers on the same flight, in essence, you can't treat them differently unless there's a good reason for doing so. And in Schenkel, the court said,
Could you give me the reference again, please?
page 90, paragraph 37 to 38.
Thank you.
So it said, to interpret Article 3.1a in such a way that a flight includes an outward and return journey would further amount to depriving passengers of their rights in a situation in which the flight departing from an airport located in the territory of a member state is not operated by a community carrier. Passengers on such a flight who had originally departed from an airport located in a non-member country would not be able to enjoy the protection provided by Regulation 26104. By contrast, passengers starting their journey on the same flight would be able to enjoy that protection, as they would be regarded as passengers departing from an airport located in the territory of a member state. Passengers on the same flight, whose protection in respect of harmful consequences must be the same, would then be treated differently. So in this case, if you had a passenger...
Hang on a minute. In Schenkel, the claim failed.
Yes, my lord.
So that's not part of any reasoning that gives rise to the judgment in Schenkel. Because in Schenkel, the court ruled again that although you have to look at it as a unit, the outward and inbound flights were separate.
Well, my lord, it is part of the reasoning, because in Schenkel, the claimant was advocating for his journey out and his journey back to be considered one unit.
Yes.
And the Court of Justice said, we can't take that approach, because if we did, it would lower the protection given to passengers. Although it would help this particular passenger, generally, it would lead to a lowering of standards.
But that must mean that, depending on the booking, in Schenkel, or yes, depending on the booking, there might be different claims for different people.
Depending on the booking, my lord.
Well, depending on the unit that was booked.
So, my lord, the point in Schenkel was that you couldn't take the out and back legs as one journey.
Exactly. So the claim failed, notwithstanding the equal treatment provision.
Yes, my lord, because if you took the out and back legs as one unit, you would be treating people differently. You would be resulting in a situation where people operate. The flight back, let's say the flight back, this is what the Court of Justice says, the flight back is operated by a community air carrier. Normally, you would expect people starting their journey on the flight back to be able to claim. But if you take it as one unit, that doesn't work, because you have to look at the whole thing.
What are the flights in Schenkel?
So the flights in Schenkel were, it was a outward and return journey from Düsseldorf to Manila via Dubai. So he was flying out to Manila via Dubai from Düsseldorf and then back again. And the claimant's argument was...
With who?
With who? With United Arab Emirates Airlines.
So not a community carrier.
Exactly.
No.
And what was said? It was said that because it was they left from Düsseldorf, but they presumably stayed in Manila some time.
Well, indeed, my lord, yes. So it wasn't a case of directly connecting flights.
And where was the delay?
So the delay was on the return leg, I believe. So if I go to the facts of the case, so this is page 88, paragraph 14 following. So for the return journey, Dr. Schenkel had a reservation from Manila. The flight was cancelled because of technical problems. So Dr. Schenkel's argument, paragraph 16, was that the outward and return flights were non-independent parts of a single flight, and since the point of departure of that single flight was Düsseldorf, he was thus a passenger departing from an airport located in the territory of a member state, within the meaning of Article 3.1a of that regulation. And the court said, well, you can't take that approach. You can't treat an entire journey, which is the term the court uses, there and back, as a single flight. You have to break it down into individual component flights.
Well, you have to. They didn't break it down into they just broke it down. There's a flight to Manila and there's a journey to Manila and a journey back.
Of course, my lord,
They didn't
yes.
worry about the intervening legs to Dubai, the stopover.
They weren't concerned in that case with that issue.
No.
Although I would submit that the same logic that the court adopted in Schenkel would apply in the case of, in this case.
So those are the facts. So just help me with this. How does the equal treatment point relevant to the decision that no, that's not a single unit, but two separate journeys? How does the equal treatment point sound in that?
So the court said, if, in a hypothetical, the journey back had been operated by a community carrier, then passengers starting their journey in Manila and flying into the EU wouldn't have a right to claim, because you're taking the flight out and the flight back as one unit. That would be...
Sorry, now, hypothetical...
Sorry, no, I got that wrong. Apologies, my lord. If the flight back was a community carrier and you took it as one unit, then passengers who had started in Düsseldorf, flown out and flown back, wouldn't have the right.
They would.
They would.
Passengers on such a flight would originally
They would
departed.
318.
Yes. No, that's right. Yes. So let's say I was confusing that by reference to a community carrier, and I apologise. The point is, if it's not a community carrier, passengers starting on a flight from Manila wouldn't be able to claim, but passengers who started at Düsseldorf, flown to Manila, and then flown back would be able to claim.
Yes.
So that's not treating them equally, because both passengers from Manila to Düsseldorf, or both passengers on the flight back suffered the same inconvenience.
Well, that assumes that there's equality to be between people who do a return journey and people who only do one journey.
Yes, my lord. So it does assume that you're looking at the individual components of the journey, which the Court of Justice clearly is in this case. The Court of Justice is concerned with equality of treatment on individual flights, or that's what it appears to be in this case. So the exact wording, passengers on such a flight who had originally departed from an airport located in a non-member country would not be able to enjoy the protection provided by the regulation. By contrast, passengers starting their journey on the same flight would be able to enjoy that protection.
But is that saying any more than Wegener doesn't apply to a return journey because there are two journeys? You go and you come back.
Well, not directly, my lord, no, but by analogy, yes. So I draw 2 points out of this. The first is that the court is concerned here with the situation of passengers on individual flights, or appears to be. The second, which is the broader point I'd make, is that the same logic would apply in the present case. So if you had a situation where an individual, let's say that Wegener prevents the interpretation that the appellant is arguing for, and so the appellant isn't liable to claim. But someone starting their journey to Bengaluru from London Heathrow would be able to claim. So they haven't taken any connecting flights from the USA, they've just got up, gone to Heathrow and taken off from there. They're in different positions, the appellant and this individual who started their journey at London Heathrow. And what we have here is a direct line of authority from the Court of Justice saying that that's not an acceptable situation. You should treat passengers equally wherever it's possible to do so. And what I would note, my lord, is that there is, once again, and I must accept this, the possibility for inconsistency here. There are going to be circumstances where equal treatment falls flat. So,
well, there are going to be circumstances where equal treatment is going to potentially deny a good claim.
Potentially, my lord. But the case that the respondent has cited, or the instance the respondent has cited, I should say, at paragraph 73 of their skeleton argument.
So, hang on. If you have a case such as my lord has just suggested, where equal treatment is going to deny, what do you do? Just bin equal treatment and give them compensation anyway?
That would be my submission, my lord. I'd say the passenger protection principle overrides equal treatment, but that ideally, if it's possible to do so, and if there are no bars to doing so, one should apply the principle of equal treatment. But you can see that the case of Schenkel was one where the court looked at the equal treatment argument and used it as a basis on which to deny the claimant's claim. So although they were concerned with passenger protection...
I'm speaking for myself, I'm not sure that that's a fair description of paragraphs 40 and 41. I mean, I appreciate there's a reference to the equal treatment in the paragraphs we've looked at, but in 40-41, the concept of flight must be interpreted as consisting essentially as an air transport operation, being as it were a unit of such transport performed by an air carrier which fixes its itinerary. By contrast, the concept of journey, and then it goes on, it follows that a journey out and back, paragraph 47, cannot be regarded as a single flight.
I do completely
There's
accept
nothing there about equal treatment.
No, my lord, although I would
appreciate there is in the previous paragraphs, but in terms of reasoning...
No, my lord. So what I'd note solely is that paragraph 39, directly before, deals with the treatment of the principle.
Yeah, no, I follow that.
Yeah, and then it goes on to say, in light of all the above considerations. But I completely accept the point your lordship makes.
Yeah.
Okay. The broader point is that my learned friend makes this point in his skeleton argument, paragraph 73, but in essence, my learned friend points out that in a situation like Wegener, where somebody had started their journey at Casablanca and not at Berlin, they would fall outside the scope of the regulation and they wouldn't be able to claim. And that is a failure of the equal treatment principle, because the claimant in Wegener was able to claim, despite the fact that someone on the same flight that was delayed from Casablanca to Agadir wasn't able to. Now, I'd submit that the reason for that is very clear. It's that in circumstances where a passenger never comes within the territorial scope of the regulation, there are no grounds for the EU to be imposing liability at all. And the EU can't get around that by reference to the principle of equal treatment. That would be really imposing extraterritorial jurisdiction by saying no matter where a delay occurs, so long as there was an EU passenger on the plane, we're entitled to impose compensation.
This doesn't refer to individuals from countries at all, it's just passengers. Passengers on such a flight.
Yes, my lord. Yes. But my point is that if someone takes off from Casablanca and flies to Agadir, if that flight is delayed, there's no
territorial.
Exactly. There's no territorial gateway. Yeah.
Okay.
That's as simple as that. My Lord, those are really my submissions on equal treatment. I don't place a huge amount of emphasis on it, except to note that there is a risk of a breach of the principle in circumstances I've outlined, where someone has started their journey at Heathrow if the appellant's claim is denied.
Yeah.
And am I right in thinking that the quantum of compensation is assessed by adopting what I'm going to call a Wegener approach?
Yes, my Lord. So that's the case of Boston, which is at... Yes. But in essence, you take the great circle distance, so the curved distance across the Earth, from final destination to initial point of arrival, or vice versa. And the reason for that, my Lord, is very clear. It's because, as the Court of Justice has stated, the relevant inconvenience is the inconvenience suffered at arrival. You're concerned, if you're taking a trip from point A to point D, you're concerned with how long it takes you to get from point A to point D, not how long it takes you to get from point A to point B if that doesn't affect your journey to point D. If that makes sense.
Yes.
Yes. Thank you, my Lord.
Makes sense unless you're the person delayed.
Well, indeed, my Lord. My Lord, I don't have very much more to say, so I hope to be able to wrap up the remaining points relatively briefly. Those are my submissions on the principles, and those are my submissions on the interpretation of the regulation in its natural wording. My primary case is that you can read the regulation quite happily, although I accept the force in all of your Lordship's points about the difficulties of doing so in light of Wegener, to cover the appellant's situation, and that, in any case, the principles of EU law advocate for adopting such an approach, and that this court is, pursuant to Parliament's intention as expressed in the EU Withdrawal Act, supposed, ideally, to follow those principles of EU law when interpreting EU case law.
Yeah.
Sorry, EU
Well, I
regulations.
think we got all that.
Absolutely. My Lord, those are my submissions on my first ground. I think I can deal extremely briefly with my submissions on the second ground. I don't understand there to be any real dispute on the test to be applied when departing from retained Court of Justice case law, which is the same test as departing from the Supreme Court's jurisprudence. So I don't propose to go into that. And the only point I want to make is that if your Lordships take the view that Wegener cannot be interpreted as I said it should, then I would invite your Lordships to disapply Wegener, or to overrule Wegener, in the narrow sense that it has defined the territorial ambit of the regulation for the purposes of Article 3.1a and 3.1b.
Well, it's really the same point, isn't it?
It is the same point,
I mean,
my Lord,
you
yes.
say we don't. If Wegener has not been read down by the CJEU, we should read it down.
Indeed, my Lord, absolutely.
It's the same point.
Absolutely, my
I
Lord.
mean, you're either right or you're wrong.
Indeed, my Lord. And I'll leave it at that.
Yeah.
Thank you very much.
Thank you very much. Anything else?
No, thanks.
Yeah, anything else? Thank you very much.
Thank you, my Lord.
Good, Mr. Turner.
My Lords, in essence, there is a single question before the court, namely the proper interpretation of the words departing from in Article 3.1a of the regulation. My case is that where a series of directly connecting flights is booked together at the same time, the words departing from in the regulation refer only to the first flight, because the flights are grouped collectively as a single unit of travel for purposes of Article 3.1a.
And you accept that's a completely unnatural construction?
My Lord, I do not accept that that's an unnatural construction. The construction suggested by my Lord Justice Coulson earlier, that when one leaves from Kansas on a trip going to India, but which happens to stop off, the natural answer to the question, where are you departing from, would be, I am departing from Kansas, but
Yeah,
I
but
happen
this
to be stopping
regulation is about flights, not about journeys. There's nothing in the legislation that talks about journeys.
Indeed, but the question of where is one departing from, in my respectful submission, is to be...
Well, that's a philosophical question. I mean, we may be, in life, we depart from all sorts of places. I mean, that's absolutely nothing to do with flights.
Well,
Here we're talking about whether you're being compensated for going on a flight.
Indeed, but if one looks at the English wording of the regulation, and indeed the wording of the regulation in all other languages, so far as I can tell, apart from German, which has a distinct approach to sentence structure,
Which they were construing in Wegener.
Indeed, but in Wegener, they specifically did not use the formulation which was referred to the Court of Justice, which used the word flight. In Wegener, they were very conscious of not using the word flight because they were aware.
But in Wegener, they were deciding something completely different. They were deciding whether you should be compensated on the basis of delay, which was the whole point of overall delay, which is what the regulation's about. But it doesn't actually construe the regulation in the way you want it to be construed, whereas all the other cases make it clear that they are talking about the leg.
In my submission, Wegener, it was looking at the territorial ambit of the regulation, and that was an issue because the question was, could you split the journey or the unit of travel into individual flights, into individual departures and takeoffs? And perhaps it would help, I wasn't planning to do this at this stage, but I'm very happy to take the course if it would assist, to the part of Wegener where they specifically lay out this question, this binary option between splitting up the journey or the unit of travel into multiple flights, which is what the claimant which is what the airline wanted in that case, and treating the unit of travel or journey as a single cohesive journey. If I could ask the court to please turn to page 347 of the bundle.
Yeah.
And the specific paragraph I'm looking at is paragraph 15 at the bottom of the page.
They were only referred to Air France, nothing else. Is that right?
My lord, in that case, the Air France case, as I will suggest later on, was important because the Air France case was what confirmed for the CJU that it takes this single unit of travel position with regards to flights. Now, the innovation, the move in Wegener was to apply the Air France case to Article 3.1a. And as my Lord Justice Coulson points out, this is undoubtedly a 3.1a case in circumstances where there are 7 or 8 references to Article 3.1a. So that is what they were construing.
Well, I don't think anybody doubts that. The question only is whether they were doing it in the context we're presently looking at.
My submission is they were. Could I perhaps read out paragraph 15, which is the paragraph that I wanted to refer the court to on this binary choice?
Do be careful not to construe CJEU judgments as deeds, won't you, Mr. Tennant? They're very far from that.
I'm sorry, I missed the...
Don't construe judgments of the Court of Justice of the European Union as if they were either English judgments or deeds.
Indeed, I accept that point, but nonetheless, in terms of working out what the CJU was seeking to do in Wegener, which is the question before this court, they did lay down 2 options in Article 15, which is just before they get to the operative parts of the judgment, where they decide on what the responses are. The court said, it should be noted that if a flight such as the second flight, which was made entirely outside the EU, were to be considered a separate transport operation, it would not come within the remit of Regulation number 261/2004. It's option 1. And that was what was the airline, in that case, was arguing for, that each flight should be considered separately within the meaning of Article 3.1a. Option 2. On the other hand, if a transport such as that at issue in the main proceedings were to be considered as a whole, with its point of departure, now those words, point of departure, are important in my respectful submission. Departure referring to departing to, so it's point, singular, of departure. In a member state, the regulation would apply. And that was what was being argued for by the claimant, Ms. Vegena. So that is the whole unit of travel. So in answer to your Lordship's question, in my respectful submission, Vegena was directly on point and indeed determinative of this question before the court today. Is a journey to be treated as a single unit, is a unit of travel to be treated as a single unit, where it is directly connecting flights with one point of departure and one point of finishing, or can you split it up into multiple different flights or individual units? And in my respectful submission, Vegena decides the
But you
position.
couldn't decide it for all purposes as whether it's one or the other, because it wouldn't work and provide any consumer protection at all. So you have to, it has to depend. I mean, the whole rationale of Wegener is to give protection to a person who embarks on a journey from the EU.
In my submission, the purpose of Wegener is to interpret the regulation. Now, the regulation is to be interpreted in the context, of course, of passenger protection, and I absolutely agree that that is one of the purposes of the regulation. But if one takes the perspective that the purpose of the court in all cases is to strive to find a way to protect the passenger, then we would not have cases where the passenger loses, as was the case in this court, in Blanche recently, as was the case in the OI case in the CJEU, where courts have declined.
What Blanche is about. If you're going to refer to Blanche, you better share it to us.
Certainly. Blanche is at
Blanche is the delay caused by the air traffic control.
Indeed, beginning at page 363 of the bundle. And I can just take the point from the head note, unless the court wants further assistance on this, but I just use Blanche to illustrate the very short point that even in circumstances where claimants argue that a purposive interpretation of the regulation should be chosen such that the court should strive to find in favour of the passenger, there will be circumstances in which the wording of the regulation does not permit of the interpretation that the passenger seeks to argue for. And Blanche was one of those circumstances. In that case, as my Lord Justice Coulson mentions, it was to do with a air traffic management decision, which itself was based on inclement weather. But the point I use that case for is simply the short one, that the passenger rights trumps all argument does not always succeed.
That was because Article 5.3.
Indeed. But
So there was a specific provision which excluded cover.
Well, it was certainly arguable in that case as to whether the relevant paragraph of the introduction to the regulation, the recitals, covered this particular scenario. But
I see. This is my Lord's judgment, so he'll remember that.
so it was a question of there is a specific reference to air traffic management decisions in the recitals, and the question was where an air traffic management decision is not necessarily based on objective ground or grounds which are objectively correct, whether the airline can simply take that decision as being the decision it has to follow, and whether it needs to second guess that decision.
It didn't.
Which it didn't, of course.
But that goes
Indeed.
back, in a sense, that goes back to the point that I was putting to Mr. Gillow, that that's back to extraordinary circumstances.
Yes.
Whereas we're concerned with rather different provisions. So I would have thought that you say, well, it can't decide it. It can't always be decided in favour of the passenger, and that the jurisdictional cases that support that are OI and Schenkel.
My lord, yes, indeed. Those are.
Those are not concerned with extraordinary circumstances, which is a different, potentially a different concept.
Indeed, my lord, that is correct. Although I would add also that this concept of balancing the interests of consumers and airlines is not only to be found in the discussion of the extraordinary circumstances regulation, and there is a reference to that need to balance in the Advocate General's opinion in the IATA judgment, which I plan to come to later, but I can give the court the reference for that if that would assist at this stage.
Can I just pick up on something
Yes.
that my Lord the Master of the Rolls asked? Is it the position that whichever interpretation is adopted, some passengers will win and some will lose? And if that's right, are we in a position to tell which is going to provide more passenger protection overall? Or is that a task that we should embark on?
My Lord, I would suggest it is, in answer to the first question, it is not something where there is evidence before the court, and I would suggest it's not something where one can easily conceive of there being evidence before the court that would be conclusive as to.
It's simply obvious that if passengers transiting through the EU are covered, there will be massive more passenger cover than if they're not, because there are zillions of people that travel from outside the EU, change in London or Paris or Munich or anywhere else, and go outside the EU again, and that's a very large number of people. I mean, that's a point in your favour if one is looking at it economically. This would have a massive economic effect on airlines.
Well, indeed, my Lord made the point earlier. This would have a massive commercial effect. I fully agree with that. And in those circumstances, one has to take into account, for example, when thinking about the overall consumer welfare point, what would happen if flights went up by a certain amount of money in terms of their price.
We can't look at that, but in answer to my Lord's point, can we say whether finding in this particular case, in this particular way, would protect more passengers? I would personally answer that as saying we obviously can. We don't need evidence for that.
I accept that could be said of this case.
It seems almost inevitable that there's no quid pro quo of exclusion if that's the proper construction.
The point I'd make in response to that is that passenger protection is not and cannot be the only principle on which this regulation is to be construed. Another one is the interest of airlines, and I fully accept that the interest of airlines may be a weaker motivation, but a very important one, and this is a fundamental question, it is the limits of interpretation of the legislation, particularly in light of the case law which is already extant, and the extension to passenger protection which was made under Wegener to flights which form part of a...
Under what?
Under Wegener.
Wegener being the case?
Yes.
That we haven't looked at.
No, Wegener.
Wegener, sorry.
I follow.
Yeah, okay, that's only my fault, yeah. Wegener, I'm sure you're right.
The question here is, even in light of passenger protection, one can take Wegener as a situation where passenger protection was extended to the flight outside the EU. The question now is whether it is a legitimate act in terms of the interpretation of the regulation to maintain the protections which were granted by Wegener in terms of extending the protection to the flight which departed from Marrakesh to Agadir, but then bank that and say that notwithstanding the flight there was treated as departing from the EU because it was a single unit of travel booked all at once, say nonetheless you can, in circumstances such as those of the claimant, decide to split up the flight in those circumstances. So that is the issue.
It would take out every flight out of Europe or now the United Kingdom, which touched down in Dubai, and then went on from there, or had a connecting flight from there.
It would.
I'm just niggling away at my Lord's assumption that it would lead to a massive increase. Because at the moment, I'm just not entirely convinced, but we can argue about that some other time.
I mean, Wegener puts into protection the very many flights that fly out of London to Australia and the Far East and so on that stop off in the Middle East if the delay is on the second leg. So Wegener has put into protection all those flights. The ones that Mr. Gallo wants to put into protection are the other half of the same story, which is those that start outside the EU and finish outside the EU, and that, as we know, is absolutely, a vast number.
Indeed.
Because people in the Far East travel to America through Europe, people in the Middle East travel to America through Europe, etc.
Indeed, and ultimately this question is one of interpretation of the relevant statutes.
None of that matters.
And it is to be interpreted taking into account things like passenger protection, but one has to maintain in view that the central task is interpreting the words of the legislation in the context.
I mean, the
of
problem I've got,
decisions
and
made.
Mr. Turner, you'll think about it over lunch, but and please think about the submissions you want to make on the French case over lunch too. But the problem I've got is that the words really of Article 3(1)A don't really address themselves to journeys. They address themselves to flights, without the German meaning. So it is a bit illogical, even if we were applying a strict common law interpretation. But there we are. Should we start again at 2?
Certainly.
All rise.
Or could somebody send me you did send me a soft copy, but you didn't send the French version. You sent the other one, and
My Lord, I'll ensure that we get those over to you.
Thanks.